Hi, I'm Gina Johnston.
And I'm Thomas McFarlane.
In this video, we are going to look at recovery of expenses.
So having pursued or defended your case and hopefully having been successful, you should then be able to recover some of the sums you have expended in respect to legal fees and expenses from the opposing party. Now, whether an award of expenses is made in a matter is at the discretion of the court. However, the general rule is that expenses follow success. Normally it is clear who has been successful, but in some cases this may not be as straightforward, and it is possible for opposing parties to be successful in respect of separate parts of their case, such that each party may have a claim in expenses against the other. Typically, however, it will be a single claim by the successful party against the unsuccessful party. The key point to bear in mind is that even if a party is wholly successful at court, they will not recover the full legal costs and expenses they have incurred from the opposing party. Parties therefore require to budget accordingly. A successful party who has been awarded expenses by the Scottish Court, referred to as judicial expenses, can only expect to recover between around 25% to 60% of the fees and outlays they have incurred. However, it can be less, and this is all dependent on a number of factors which we will come on to consider. This includes the hourly rates charged by the solicitor, the extent of solicitor and client work undertaken, the scale of the award of expenses by the court, and whether the party has been successful in claiming what is referred to as an additional charge uplift.
The court has the discretion to choose the scale of an award of expenses. Expenses can be awarded on one of three scales. Firstly, party and party. Secondly, solicitor and client third party paying, and lastly, solicitor and client paying. The party and party scale is the default position in most types of case. Party expenses only cover those charges reasonable for the conduct of the case in a proper manner, and this covers more than the absolute essential steps in litigation, but exclude work which might be considered above and beyond what is necessary, or work related to providing a client with a high quality service. Under this mode, expenses are taxed on the basis of the scale fees set out in the table of charges, and we will come on to explain how this works. Solicitor and client expenses cover all work done for the client's benefit, and not only that work which is strictly necessary to advance the action. If an award of expenses is made on the solicitor and client scale, a party is much more likely to recover a sum closer to 100% of their actual spend. However, in practice, such awards are relatively rare, as it must be shown that the opposing party has conducted the litigation incompetently or unreasonably in some way, and thereby caused the other party unnecessary expense. By awarding expenses on the solicitor and client scale, the court is effectively sanctioning the conduct of the opposing party.
So once you have an order for expenses in your favour, how do you go about calculating what you're entitled to recover from the opposing party? Well, firstly, you need to prepare a judicial account of expenses, and that's normally drafted by a specialist law accountant. Commonly referred to as the account, it must be prepared and served on the opposing party within 4 months from the final order on the court on expenses. Now, the unsuccessful party will then be given a chance to lodge any points of objection, and if settlement is not agreed, the matter will proceed to a diet of taxation, and that's before the auditor of court. And they're an independent person appointed to determine the expenses that should be paid by the party, having considered all of the relevant documentation and, where appropriate, heard submissions at the diet of taxation, which is essentially a hearing. At the conclusion of taxation, the auditor issues a report, and that's binding on the parties, although there is a right of appeal to the court. If an additional charge or additional fee is awarded by the judge, then the auditor of court takes that into consideration in his report, applying the appropriate percentage uplift. However, as mentioned previously, it is also possible for the court to ask the auditor to determine the additional charge as part of their independent review. In reality, the vast majority of accounts are agreed between the parties, with neither party usually having the appetite to incur more time and cost in having the matter decided by the auditor of court. It's worthwhile at this stage considering how a judicial account is prepared and how that affects recoverability. It's effectively split into two separate parts. a calculation of the solicitor's fee element, which is recoverable, most commonly on the party and party scale, and the disbursements, which are recoverable, including any court fees, counsel's fees, and expert witness fees. The solicitor's fee element is calculated by reference to a table of charges, set by statute, and must be followed by the auditor. Unless the table of charges specifies otherwise, an account prepared on a party and party basis can be prepared on one of two bases. The first is the inclusive charges, also referred to as the block fees basis. These provide for a set fee for each particular piece of work in a case, regardless of how long or how much work was actually put into it. For example, the table of fees provides for a set figure for lodging each inventory of productions. That fee will be the same whether it took 5 minutes or 5 hours to prepare. The auditor may, however, increase or decrease the fees. The second basis of charging is the detailed charges. Now, these provide for a rate per hour or quarter hour. However, there are still some set fees included, such as for framing affidavits. The rates, however, are still unlikely to match the actual rates paid by the client to the solicitor for the same piece of work. Now, most accounts are prepared on the basis of the detailed charges, as that normally leads to the highest recovery for the successful party.
Court fees will always be recoverable in full by the successful party. There are court fees payable for lodging certain types of applications and documents with the court, as well as for the court's time. Advocates' fees, or counsel's fees as they may be referred to, are almost always recoverable in full in the Court of Session, although it remains open for a party to argue that they are excessive or that the action should not have been raised in the Court of Session and it should have been raised in the Sheriff Court. For counsel's fees to be recoverable in the Sheriff Court, the party must have first obtained sanction for the employment of counsel from the Sheriff. In deciding whether or not to grant sanction for the employment of counsel, the Sheriff requires to be convinced that it is reasonable in all the circumstances and will consider the difficulty or complexity of the case as well as the value of the claim or its importance. The Sheriff will also consider the desirability that there is an equality of arms in the litigation so that one party does not gain an unfair advantage by the employment of counsel. Sanction for counsel should ideally always be sought in advance before costs are incurred. Whilst there is an ability to seek sanction retrospectively, this is not automatic, and the party seeking sanction to be backdated will have to show cause for not having applied for sanction in advance. Expert fees will only be recoverable if the expert has been certified as a skilled person by the court. The court must be satisfied that the person is a skilled person and that it is reasonable and proportionate for them to be employed. Ideally, certification for the appointment of an expert or skilled witness should be sought in advance before such costs are incurred. Whilst there is also a route to have costs already incurred certified retrospectively, this is also not automatic and requires a party to show cause for not having applied for certification in advance. There are different rules for personal injury actions. Other outlays reasonably incurred to conduct proceedings in a proper manner are also generally recoverable. For example, charges for obtaining copy deeds from registers of Scotland and such like. VAT will only be recoverable as part of an account of expenses if the successful party has not already reclaimed VAT or is not able to reclaim VAT. When a dispute is resolved out of court, the position on expenses requires to be agreed, and we would always seek to recover the full expenses incurred by our clients or a contribution towards those costs as part of any overall settlement. But this is always a matter for negotiation and will be dependent on a number of factors.
We hope you found this video on recovery of expenses of interest. If you have a dispute on which you require legal advice, then please do get in touch.